Hi everyone, welcome to the webinar. I'm going to give everyone a couple minutes to log in from the waiting room and get the closed captions up and running. When the closed captions are up, you should see a red box that says live at the top of your screen, and you can click on that to access the closed captions. And I'll also put that link in the chat box, and just let me know if there's any problems with it. So it looks like it's acting a little funny like it did on yesterday's webinar. So hopefully it will actually be running during the webinar. All right, well, happy Friday. Welcome everybody. I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services. And I'm glad to see so many people interested in this topic on a Friday. And at the end of the year, this is the last webinar of the year. And today we'll be talking about frequently asked questions representing immigrant survivors of domestic violence. And our speaker today is Nicole Avila. She's an attorney at Florida Legal Services, and she's part of the Holistic Survivor Services Unit at FLS. And I also want to thank the Public Interest Law section of the Florida Bar for co-sponsoring this. They are working on the CLE credit, I promise, but it hasn't quite come through yet. So I'll send that out to everyone once I get it. This is being recorded, and I'll send out the recording to everyone by tomorrow, along with lots of resources that Nicole has generously agreed to share with everyone. So welcome everyone, and I'll turn it over to Nicole now.
Thank you, Christy. Hello, everyone. My name is Nicole Avila. And as Christy said, I'm one of the attorneys here at Florida Legal Services. So this webinar is basically going over issues that we see with immigrant survivors of domestic violence when we're representing them in court and things like that, especially when we have folks at the domestic violence centers or sex assault centers and shelters. So first, I want to go over some of the legal provisions and protections that VAWA offers, and VAWA is the Violence Against Women Act. So this, the confidentiality provisions for VAWA prohibit reliance on perpetrator-provided information, and it also it prevents the reliance, and they can't do enforcement operations in certain locations for enforcement actions, and it applies to all immigrant survivors. So this includes people that are applying for immigration benefits under the Violence Against Women Act, also for U visas and T visas, which we're going to go over a little bit later. So the intent of the confidentiality provisions and protections under VAWA, Congress intended to design this to ensure that abusers would not be able to essentially destroy or mess up the processes and the immigration processes that the survivor might be going through. So ICE cannot get or act on information that they receive from the abuser or close family members of the abuser and things like that. So for the disclosure provisions that we're talking about here, number one, DHS, which is the Department of Homeland Security, the Department of State, and the Department of Justice are prohibited from giving out any information pertaining to any of the immigration processes, whether a process even exists or is pending at any of their agencies. They cannot give out any information to anyone other than the survivor and their legal representative. The source limitations are, like I said, they're not allowed to use solely information provided by the abuser, trafficker, or people closely connected to them, people within the same household, without verifying that in another way. And they actually have to certify that that information isn't coming only from the abuser. And then the enforcement limitations are that ICE is prescribed from performing enforcement operations in certain places like sex assault treatment centers, DV shelters, service providers, and certain courtrooms. So anywhere where there are victims or survivors that are applying for injunctions for protection, they're not supposed to go in there. Custody hearings, family law hearings, which is not necessarily the case when we're talking about criminal law hearings. But courthouses, we know that ICE does do enforcement operations there because they deem it a safer way for them to perform their job. But they are still prescribed from doing those. And if they do have to do that for whatever reasonable reason they think apprehending a survivor in a courthouse, they have to still certify that they haven't violated any of these protections and any of these provisions. And we're going to go into that a little bit more. So another background thing that I wanted to go over was about warrants. So there are a few things that we're going to go over some best practices if you are in court and your survivor is being apprehended by ICE. I think right now, since a lot of our Florida courts are doing Zoom hearings, we can keep our survivors safer. But usually they're not necessarily going to go into the courtroom, but they will maybe be in plainclothes and be in the hallways and things of that nature. So in order for them to arrest someone in public, they can have either this type of warrant, which is an administrative warrant that you see on your screen, or a judicial warrant, which they'll almost never have. But I want you to be familiar with these two documents because if they, and we'll talk about it a little bit later, if they're trying to apprehend someone at your shelter or in their home, this warrant is not sufficient to grant them access to a home or a shelter or any private areas, say a workplace, any area that's not available to the public to go in. This administrative warrant isn't enough. It doesn't come from a neutral magistrate or a judge. It's just merely an administrative document that is signed by an ICE officer or a CBP officer, which is the Customs and Border Protection, and it just says, you know, this is the reason why we think you're deportable and why we want to take you in, and it should have the person's name here. But it's not enough to grant them access to do searches into homes or any other private place where the public isn't allowed to be in general. And then
sorry to interrupt. People are having a little bit of a hard time hearing you. If you could speak just a little more loudly or get a little closer to the microphone.
Yes, of course. I'm so sorry.
That's all right. That's better.
So this is the judicial arrest warrant, and it should be issued by a U.S. District Court and allege an actual crime that has been committed by the person they're seeking to arrest, and it should name the person they're seeking to arrest and signed by a judge. And because this is a judicial warrant, it's going to be under the federal rules of criminal procedure, and it has to comply with those rules. Because immigration is almost always civil and not criminal, they're not going to be able to get this warrant. And even if they were possibly able, due to the facts of the case, it's extremely rare that they actually do go through a judge to secure a warrant. So in general, they rely on this administrative warrant because people don't necessarily know that there are different documents, that this isn't a judicial order for them to be arrested. So we want everyone that's working with survivors to be mindful of those. You can share that information with your survivors as well so that they know if ICE does come to their door, they don't have to open the door unless they have a warrant that looks sort of like this. And they don't have to let them in to search or anything like that. But if you do encounter ICE at the courthouse and they're representing a survivor, the best practice would be to stay and observe everything that's happening, document everything that's happening so that we know whether they followed the actual procedure, whether they have made those certifications when they issue the notice to appear, which is the charging document for immigration. And if they have not followed the proper procedure and they have not made those certifications, or they have falsely made those certifications, then there are lawsuits that the survivor can file to recover monetarily. The immigration process can be terminated, and there are a host of other relief that the survivor can have access to if ICE acted inappropriately. So let's go over a little bit of the FAQs that we've got for this webinar. So in general, courts are not sensitive locations under the sensitive location policy for ICE. So like I said, they can come into the courthouse, they can go into essentially any type of courtroom, except for it is a violation of the VAWA confidentiality provisions that we went over to take any of those actions in a courtroom, a shelter, crisis center, sex assault treatment centers, and other service providers. So if they do take any sort of action in any of those places, they have to certify that they did not violate any of the VAWA confidentiality provisions. And if they don't certify or they lie, it can lead to a dismissal of the immigration case, monetary penalties against the officers and the agency, and that's all found in 8 USC section 1229E. So in general, going to court is safe as long as you're in the survivor context of a family law courtroom, dependency, or IFP hearings. If your survivor is charged with a crime, then that's going to be a little bit different, because ICE is allowed to make arrests in courthouses, and we know nationwide they have been. So here is a little bit of a hypo, and I think Christy is going to put up a poll so that you can put up your answers as well. So Eliza is representing her client Alex at an IFP hearing, and Alex is undocumented. He is married to a US citizen, and he has filed a VAWA application. ICE officers arrive at the courtroom to arrest Alex. They knew that Alex would be in the courtroom that day because his abuser, Aaron, called immigration enforcement and let them know that Alex had a hearing that day. So which violations do you think happened here? Either A, a violation of the source prong, violation of the enforcement prong, violation of the disclosure prong, a violation of more than one prong, or no violation at all?
All right, we've got some votes coming in already. And everybody let me know in the chat box if you're able to hear Nicole a little better now. Okay, so far D is the most popular answer.
Yeah, and I would agree with that. We do have several violations here. So initially, I would say we have a source violation because Aaron was who is the abuser, was the one who gave ICE the information to come to court. And we don't have any other information whether ICE, had any independent investigation regarding that. So all we know is that they took Aaron's word for that Alex was going to be here. So yes, that would be a violation of those prongs. It would also be a violation of the enforcement prong because they came to an IFP hearing, which they are proscribed from doing by statute, and to come and arrest a survivor. So good job, everyone.
People are still having a little bit of trouble hearing.
Let me try switching to the other headphones. Maybe that'll be better.
It sounds better already.
Oh, goody.
Actually,
perfect.
And we had a question come in
Hold
too.
on. I gotta disconnect the other ones real quick. Okay, is that better?
That is much better. So
oh, wonderful.
If you don't mind, we did have a question come in, so I thought you
Go
could
for
take
it
that before we move on.
Yes.
Someone was asking, do they have to certify in person, and how do they certify? I think that was based on the last slide.
Okay. Yes. So the certification goes on the actual notice to appear document, and they have to certify and sign on there that they did not violate any of these prongs. And that's all in the statute. And I think it's in one of the documents that we're going to send after, with the actual language that they have to put on there. But in essence, it's a written certification under oath that they haven't violated any of those any of these prongs. And if they lie on that certification, and which is why I said, if you are representing a survivor that is being arrested by ICE in the courthouse or any other location where ICE shouldn't have gone to keep observing. Don't interfere in the arrest, but do observe and document everything. You are allowed in general to record ICE doing enforcement actions. So if you can, that's perfect, because that will enable the immigration attorney that will step in to do that removal case to go ahead and maybe file a motion to terminate based on the fact that these prongs were violated, or get involved with a civil litigator to sue the agency for violating the VAWA confidentiality statute.
Okay. And a related question, how do you prove that the abuser is the one who called ICE?
So that is a difficult question, because that limitation, this is going to be kind of redundant, but that limitation is limited. So they can't act solely on the information that the abuser gave to ICE, but they can take that information and then go into the public record and use the information they gathered in the public record to perform enforcement actions. So that one isn't as much of a protection as some of the other ones, like the location enforcement prongs, because obviously it's very hard to prove, and they can take that information and then corroborate it through some other source. Let's say the docket, they can just check the clerk's docket or any other public information that they have access to. Then so that one is not as big of a protection, but it's very difficult to prove. Sometimes abusers tell the abused that I called ICE, and then you would have to file for enforcement of the VAWA confidentiality statute, do that lawsuit, and at that point you would have discovery. So that would be the way to do it if we were in a civil suit, because we suspect that the officer didn't comply with the statute and either certified dishonestly or didn't certify at all that they complied. And then we would have to do some discovery in that civil suit to get to whether, if that was the source. But that's not as protective of a prong as some of the other ones, because like I said, they just can't act solely on the information they're getting from the abuser, but they can verify a lot of that information another way.
Okay. And one more question on that note. So there's no fruit of the poisonous tree argument? There is not. That is a great question, but no, unfortunately, there is no such argument for this statute. They can, and I think, I can't remember if it's in the practice advisory that we're sending or in the actual statute, where it says, they can independently verify any of the information based on public record. Like, they can just go to the clerk's website and see that there's a hearing in a certain case, if that's public information, and then show up to court in that way. But they're still proscribed from making arrests in those types of courtrooms. And so you would, there are other ways for them to effectuate that arrest. And so it's not always going to be 100% safe for folks, especially folks that are undocumented. But once the service, the U.S. Citizenship and Immigration Service, knows that there is a survivor-based application coming, they mark the file under Code 384 for the section of the law, and they are supposed to stop enforcement actions, and they are supposed to keep the information
safe, so that there are no disclosure violations and the survivor should be protected. Of course, we know that that doesn't, well, we know that they code it, but we know that ICE doesn't always necessarily stop from doing enforcement actions on certain folks, especially if we have folks that have criminal records and things like that, or are otherwise removable because they have an old removal order and things of that nature. So what we try to do when we know that there is allegations of abuse is move as quickly as possible to file applications for relief so we can keep that person safe.
Okay. All right, we had another question come in, but I think you're going to cover it next, so I'll wait on that.
Okay.
One. Thank
All
you.
right, awesome, thanks. Oh, hold on. There we go. Okay, so what are the effects of an arrest or conviction? Did I skip one? Yes, I did. Sorry. Okay, so here's another hypo that we have, and we're still in court. Alexis represents Moira in her dissolution of marriage. Moira is undocumented but has filed a VAWA application. During the hearing, the judge asks Alexis to disclose Moira's immigration status and whether she has any cases pending. The judge is worried about Moira being arrested by ICE while her son David is in her custody. So what should Alexis do to protect Moira's interests? Give the judge all the receipts, file a motion for a protective order, let everyone know there's a VAWA pending but nothing else, or ew David. And I know I haven't given you the answer for this one yet, but I want to see what you would do if you were in court and this happened. I appreciate everyone, the three of you who have chosen EO David. Thank you for that.
Give everyone a few more seconds to vote. All right, so far 65% voted B, file a motion for protective order.
Awesome. I'm so proud of everyone. Thank you. That is the correct, that's the best practice. So the reason for that is, even in state court, while they're not necessarily part of the Department of Justice or the Department of Homeland Security or the Department of State, we do have to protect that information. They can't get it any other way other than the survivor or the attorney that knows what's going on, right? So it is still like they can't just call DHS and get that information. They can't subpoena USCIS and get that information because they are prohibited from disclosing any of that. So usually what we want is we want to file a motion for protective order. We can let the judge know that we can't even confirm or deny whether a case is pending with immigration, because even that information is fully confidential, and we can let the judge know that much. But sharing receipts with the court, which are obviously going to go to the other party, can be very dangerous for the survivor, because it places them at risk that the abuser is going to know exactly what they're doing. The good thing is USCIS does not post case status updates on their website. If you were to plug in the receipt number, you can only contact the Vermont Service Center directly to get that information, and you have to verify that you're the survivor or the attorney, and you already have a notice of appearance on record to get any information from the Vermont Service Center. But we wouldn't want the abuser to know what process they're in. We don't want them to have any access to any of that information because, then we know they can call ICE. And even though we have these protections, they're very limited. So the more that we can protect and safeguard that information and just let the judge know, even if something is pending, we can't tell you whether or not it is. And these are the protections. And one of the things that we're sending out to you is a brochure that explains this in a lot more depth, with sort of the information on the motions for protective order and what we can do as attorneys to protect our clients. And this is actually based on a true story of a case that happened in Broward County. So we are the ones who are there to protect our clients. And the judges might not, like this judge was just worried about David. They're not, they're not trying to get Moira in removal or anything like that, but they're just worried that ICE might come if she's undocumented, and then that David might witness that. So in any case, the idea is to keep the survivor protected and that information safe and away from the abuser. Do we have any questions on that, Christy?
Yes, we did have some questions come in. One was someone wondering if dependency and family law court is considered a protected or sensitive location.
So the courthouse in general, any courtroom is not considered a sensitive location, but it does have, so it protects the survivor. If we don't have abuse allegations or the person is not a survivor of human trafficking, domestic violence, or other qualified crimes, so they can't apply for VAWA, T's, or U visas, those courtrooms are still not sensitive locations. What we have is the protections only if we have a survivor who is undocumented or an immigrant that can apply for any of these benefits, and who might be removable. That's when these protections kick in. So it's not courthouses in general are not sensitive locations.
Okay. And the next question is, can we file the motion for protective order in a domestic violence case also?
Yes, I would say any type of case that you have where there is a survivor, like whether you're in family court or you're doing the IFP, I think you should still try and file that. I'll say that I don't know how well versed the judges are in this area yet, but I do know in at least some of our jurisdictions in Florida, they are working on it. I do know that I think the Judges College did have a section on this, and I know in Broward, we've brought this up before through our bar association. So I think they are working on it, but we have to educate the judge, even if they're not totally receptive to this, and explain why that is. But I would file that because it's possible the other party is going to try and get that information because they think they might be disadvantaged because this person is filing an abuse-based case. And just kind of general information, because all of this is completely confidential, in general, they're not going to go after the abuser. Like USCIS isn't going to call them for an interview and say, did you really abuse your wife like this? Or anything like that. They're not going to contact anyone. Everything will be done on paper, except for whether the survivor is admissible, and they'll have an interview just on admissibility at the end of the case. But everything else is done on paper at the Vermont Service Center. I hope that answers the question.
Yes, that's great information, and I saved the best for last. Does being prohibited actually stop USCIS?
From
anything.
Okay. So USCIS is the benefit granting agency. I'm not sure whether I mean ICE or USCIS itself. So USCIS is prohibited from giving out any information, and it does stop them from giving out any information. The Vermont Service Center is a specialized unit that deals with survivor cases. That's where all of our UTs and VAWAs go. So in general, in my experience, I've never had a case where they actually disclose any information to anyone that they're not supposed to. And in fact, it's almost to a fault, because it's difficult sometimes for attorneys that are taking over cases, if they haven't gotten our notice of appearance yet and things like that, for us to communicate with them. But it is a specialized unit that deals with these specific types of cases. And in general, they don't act like the rest of the agency. And they are supposed to be client focused and victim focused and centered. So I haven't had that experience with USCIS. ICE is different, and it's a separate agency, even though they're part of the Department of Homeland Security. So it doesn't mean, and like I said, all of these protections they are proscribed and prohibited from doing certain things, except for they can do them as long as they certify that they did them correctly. So even though the statute says proscribed and prohibited, it's not a total prohibition, because they can still do some of it in those places as long as they certify they basically had no other way. But I haven't seen, and you guys might know better than me on this part, I've never had a case where they tried to do enforcement actions at a shelter or a sex assault treatment center or any service provider. And I do know that nationwide we have seen some enforcement actions in courtrooms and things like that. But as far as I know, most of them have been in criminal cases that are pending and things of that nature. But, you know, just be aware, once we can start going back to court, ICE can show up, they can be in the hallways. A lot of times they won't identify, like they won't be wearing that ICE jacket or anything like that. They might be in plain clothes, and they might just identify themselves as police, and you can ask, you know, am I free to go? And if they say yes, then just walk away slowly and say, you know, I don't want to talk to you. I don't want to answer any questions. And if they say they're not free to go, then just state, you know, I have an attorney, or I want an attorney, and I'm not going to answer any questions. They're not entitled to an attorney as in the criminal proceeding, because it is not a criminal proceeding, it is civil. So they're entitled to counsel, but at no expense to the government. So for our purposes, if you are in a shelter and you have a survivor that is apprehended in that way, you can always send the referral form, which we have the link for at the end of the webinar. You can send the referral form to us here at FLS, and we'll screen the case for relief and try to help the survivor to get out of detention. Otherwise, you know, make sure that your survivors have plans in place, and things like who is going to pick up the children and things like that in the event of apprehension, and things like, you know, who should we contact, family members, do you already have an attorney you've spoken to, things of that nature.
All right, that's it for questions at the moment.
Okay, so what are the effects of an arrest conviction? So I am very sorry that I have to give you the standard lawyer answer for this one, but it depends. So the immigration consequences of criminal conduct will always vary, and it's going to depend on the specific statute, the specific sentence, what the plea was, and a host of other things, especially if the conviction or the arrest happened before 1996. Or even more if it happened before 1990, because the law has changed so many times. So if you have a client that's been arrested or convicted of any crime, it's always best for them to check with an immigration lawyer. Again, if you're part of the IFP project at the local shelters, you can send us the referral form here at FLS, and we'll screen the case. Or your survivor themselves can call the DV hotline. I put the number right here. And again, we can do the screening, provide them advice. And if we have the capacity, then we can possibly provide direct representation to them. If your survivor is arrested, let's say for DV battery, there is an exception in the law that shouldn't affect their case, you know, because obviously we know sometimes the survivor is the one who gets arrested. And it's possible, if they're undocumented or otherwise removable, that they might have an ICE hold. So you're always going to want to have that non-citizen survivor speak with an immigration attorney as soon as possible, so that we can try to get them out of detention or fight the case as soon as we can and gather as much documentation. Okay, so another question that we got is whether calling 911 or reporting a crime is safe. So usually yes, and this is the purpose of the UNT visa programs. But I do encourage everyone to check with your community partners to see how your local law enforcement agency handles these things. You want to know whether they're trauma informed and victim centered. You will also want to know whether your jurisdiction has a 287G agreement with the federal government, with ICE. And what that means is 287G is a section of the law that allows for ICE to make contracts with local jurisdictions for immigration enforcement. There's a lot of jurisdictions in Florida that have agreements in place. Most of them are agreements to hold people in jails or prisons for ICE holds, so that ICE can pick them up and put them in ICE detention. There's a map, and we'll send the link out so you can check your local jurisdiction. But in general, calling 911 is a safe thing to do. It's the reporting after the fact, or when you have law enforcement engagement, that you're going to want to have a victim advocate and a victim rights attorney to accompany your survivor to law enforcement interviews and things like that, because we don't want undocumented or removable folks going into law enforcement agencies and not knowing that they have rights, and what those rights are and the way to enforce those rights. And VAWA confidentiality does apply to these, so same thing. ICE should not be coming after the survivor for reporting these things, and it applies to all survivors, U visa, T visa, and VAWA prospective applicants. And this applies as soon as USCIS knows that you're going to be filing. So in many cases, when there's a case already pending, we send a letter saying, hey, USCIS, just so you know, there are abuse allegations, we're going to be filing VAWA, please hold the case in abeyance. And at that point, that's when they're supposed to mark the case as a VAWA case. So all of these protections can enter into play. Another question that I think is a great question is, what is the effect of working without authorization? So we can't tell folks, yeah, go ahead, work, no problem. We know it's a necessity. We know people have to support themselves and their families. USCIS knows that too. If they're working, I always advise people to get an individual taxpayer ID number so that they can pay taxes. Because when you're applying to any sort of relief, it goes to the good moral character of the person, whether they've paid taxes or not. So even if they don't have a social, and even if they're working under the table or getting paid under the table, they still should be filing taxes. And in general, having worked without authorization doesn't affect eligibility for VAWAs, Ts, or U visas, or under a subsequent immediate relative petition. An immediate relative petition refers to either a petition by a U.S. citizen spouse or a U.S. citizen child over 21, or if the survivor is under 21, a petition by a parent that is a U.S. citizen. So we can't tell people to do it. We know that they're going to end up doing it anyway. So best practice is generally to advise them they should be paying taxes if they're going to work. But it doesn't generally carry an immigration consequence in this context. So we're going to talk a little bit about immigration options for survivors. In general, we want survivors to get screened by an immigration attorney to make sure whether they're eligible for certain reliefs or not, especially depending on whether they have a criminal background or not. So, but these are some common triggers that we can look out for when we have a non-citizen survivor, and we're going to send them so that we know we have to send them for a screening. So for VAWA, which is the Violence Against Women Act, we want to know whether the spouse ever filed something against or for them, so any petitions that were filed on their behalf, and if they did, maybe they withdrew the petition. And what we need to prove for that type of case is that they were in a good faith marriage, which means that they did not get married to evade immigration law or to obtain an immigration benefit. And the spouse, the abuser, has to be a U.S. citizen or a lawful permanent resident. It could also be a child over 21 that is a US citizen that's the abuser, or if let's say we have a set of parents, one parent is abusive to one of the children, the non-citizen parent could still potentially apply for VAWA based on the abuse to the child. Obviously, that would be the non-offending parent. And then they have to have suffered battery or extreme cruelty and be a person of good moral character. For battery and extreme cruelty, the standard for VAWA use and T visas is any credible evidence. So we know a lot of times survivors leave with just what they have on. We know they're in crisis. USCIS understands that. So the standard is any credible evidence. So the primary piece of evidence in the case is usually going to be the survivor's own statements. And I typically sit down with them and prepare a declaration that accompanies our applications, and anything else that they might have. So for good faith marriage, we're going to see whether maybe we have driver license copies and they have the same address, or even junk mail that came to the house and we have pieces of mail in either of their names and they both have the same address, things like that. If the person is a naturalized citizen or a lawful permanent resident, we can sometimes ask USCIS to locate those records if we have absolutely no access or no copies of the abuser's status. For good moral character, we typically want to get a certificate of good conduct from the local police department in any jurisdiction where the person lived for 6 months or longer. And a lot of places, like I know Broward Sheriff's Office, you can get those online without having to send your survivor in for fingerprints. USCIS is still going to do a background check. So if it's impossible for us to get the police department certificate, sometimes it's from home country that we're waiting on or something like that, then I usually just advise the survivors will put that as part of their statement, why we haven't been able to get it. And what, I've never been arrested anywhere in the world, things of that nature, and explaining that they do have good moral character, and we can just provide that at a later date once we get the receipts, if it's necessary. But USCIS is also going to conduct their own background check separately from what we send. So it's not so much the evidence that we submit with regards to good moral character, it's also what they themselves are going to look into through their FBI background check. For a U visa, if you have a client that is either unmarried or they're married, but their spouse is not a lawful permanent resident or a US citizen. They have to be the victim of a qualified crime inside the United States. Regular battery is not a qualified crime unless it's analogous to like aggravated assault or felonious assault under the federal statute. But DV battery does qualify. They have to assist law enforcement, so there has to be law enforcement engagement. Law enforcement has to certify that the person had information and that they were helpful, and they, anytime that they were requested to do something or appear in a reasonable way, they did. And we have to also show the substantial mental or physical abuse that was suffered. So if we have physical abuse, photos, any police reports, things of that nature. If it's something else, maybe the person went to the hospital. So if we can get hospital records, any long-lasting effects from that. So psychological reports, certifications from therapists and things like that, that they're still attending therapy sessions and evidence of that nature. Then we have people who already have a green card. It's a 2-year green card. And then as soon as that happened, things turned sour. And now we have abuse allegations and the person doesn't know what to do. So if we have someone who has the 2-year green card, and that happens when they have been married fewer than 2 years at the time of the interview, or when the green card is granted, there is a waiver of the joint filing requirement to remove the condition. And that kicks in if there is abuse or a divorce in the marriage. So you can file for a waiver of the joint filing requirement, and you just have to show the abuse, same as under VAWA, and that the marriage was always in good faith. So same type of evidence that we want to get with respect to whether things, any mail that we have with the same address, things like that. And for the divorce waiver, the divorce actually has to be final. So sometimes they issue a request for evidence when you let them know, hey, we're getting divorced, I'd like to change my application to a waiver of joint filing requirement. They can't actually grant that waiver or your application until the divorce is actually final. So if we have abuse and they're getting divorced, I usually throw everything in there. And then for the divorce, once you have the actual final judgment of the dissolution of marriage, then we can file that with USCIS and they can grant the waiver under the divorce portion. For T visas, these require a little bit more deeper screening to determine whether they are a victim of a severe form of trafficking in persons. So you want to listen for things where the client was either married or unmarried, but if they're married, it wasn't to a U.S. citizen or a lawful permanent resident. And the relationship maybe was closer to an employment type relationship than an actual romantic or partner relationship. If, they say things like they really treated me like a servant, things like that, then we might possibly have an indication that it might be a trafficking relationship, but trafficking requires that there be force, fraud, or coercion. And if we're talking about a labor trafficking relationship, coercion's already or fraud is already part of the definition. So we're going to need something more. So we want to have that coercion or that force. And if you have a DV situation where there is physical abuse, that can usually work, but USCIS is very weary about mixed cases. When we have a DV situation that is also a trafficking situation, we really have to focus on what that labor aspect was or what the sex trafficking aspect was. So the severe form of trafficking in persons is a federal definition. The states have basically adopted that definition to their own statutes. And then they also have to cooperate with law enforcement with there's a couple of exceptions if the person was a minor or if the survivor is so severely traumatized that they cannot engage with law enforcement. And then they have to show that they would suffer hardship if they're removed. So the cooperation with law enforcement, we always recommend that if we are doing a T visa case, people do engage with law enforcement, because if we use those exceptions, we're not going to have access to certain types of benefits later on, like early adjustment of status, so where they can get a green card as soon as the T visa is approved rather than 3 years later. And then we lose some of the force behind an argument of retaliation to be able to bring family members in under the derivative status for the T visa. So it's always something that I screen for if we don't have any other form of relief for them. But it's not something that we just want to file if it's not a strong case. And the reason why we might go to the T instead of the U is that the U visa has 10,000 visas available any fiscal year, and that starts October 1st. And there are over 130,000 visas pending. So it's going to realistically take about 10 years for a visa filed today to be granted. As for the T visa, there are 5,000 visas available any fiscal year, and we've never reached the cap. So if we have an indication that the person might be a human trafficking survivor, we'll we'll do a deeper screening to make sure whether they do fit under the definition of a severe form of trafficking in persons, and whether they're ready to engage with law enforcement for the T or the U, because we want to make sure that we're not re-traumatizing our survivor, and they might not be ready. Engaging with law enforcement is not an easy process. It requires for them to tell their story several times sometimes, and to possibly go to court and confront their abuser or their trafficker. And some folks might not be ready for that, and that is required of these types of relief. So we want to screen them for any other avenue for relief that might exist for them. So one other question that we got, do we have any questions on that, Christy? Christy?
No, I don't see any questions coming in yet.
Perfect. This one is, how can the survivor change their address with USCIS? The survivor or their attorney can file Form AR11. It has to be filed by mail if what we're submitting is a new safe address. If the person has any cases pending, but you're switching to a VAWA, for instance, or a removal of conditions under the abuse element, it has to be filed by mail, and it has to be filed to the Vermont Service Center. The form is available on the USCIS website, and I put the website there. You can, for other types of cases, you can file online, so it will give you that option, but that's people who are filing for survivor-based relief are not eligible to do that online. So it has to be filed on paper, and it goes to Vermont. Usually. So for some people, it depends on where they live. So in case what I just said changes at any point and it's not Vermont, the USCIS website here, uscis.gov/address change, you can find the direct filing addresses there as well. We also got this really great question. What are the consequences of immigration fraud? And this refers to marriage fraud, which means entering into a marriage for the purpose of evading U.S. immigration law. Anytime you have an interview at USCIS, the officers will go over this with the petitioner and the beneficiary, and there's posters all over the office about what this means. They have some catchy slogan of, if you walk down this aisle for the wrong reasons, you're gonna walk down this aisle, and they have a picture of like prison cells down an aisle. So either party can be prosecuted for this, either the US citizen or the foreign national spouse, and it's a felony. The penalties are $250,000 in fines and or 5 years in prison. And it could be both. And they can go after the US citizen and the foreign national spouse. I also linked the ICE brochure that I just mentioned with the catchy slogans and things like that and the pictures right down here. And it gives more information on what that is. I've never seen an actual prosecution of immigration fraud. They have to have a lot of evidence in general to accuse somebody of immigration fraud. And like I said, when we are talking about a good faith marriage or a bona fide marriage, we're saying they did not enter into the marriage primarily for the purpose of evading immigration law or getting an immigration benefit. So obviously immigration status is always going to figure into a foreign national getting married. That's always going to be a consideration. It can't be the primary consideration, but it's always going to be something that the US citizen spouse is entitled to and has a right to their spouse. So they have the right to petition for their spouse, and the other person wants to feel safe. So it's always going to be a consideration. It just can't be the primary reason why somebody gets married. The general standard that the case law talks about is, did you intend to form a life with this person? And you show that through pictures of trips, itineraries, I guess not in 2020, but in general, historically, we've provided photos of trips that people have taken, hotel receipts, plane itineraries, mail that they receive, cards that they give each other, photos of them with their families, holidays, things like that. So, but it's a very high burden. Obviously, this is a criminal case, so they're going to have to prove that fraud beyond a reasonable doubt. Okay, so now let's open it up to questions. So type your questions in and Christy will give me your question.
Thank you for all that great information, Nicole. I don't see any questions at the moment, so everyone, get your typing fingers ready. Expert some questions. And I just did want to remind everyone that the recording and the materials will be sent out tomorrow. So just let me know if you don't happen to receive those. And CLE is still pending, so I'll send that to everyone as soon as I get it. Don't see any questions yet. Let me make sure nothing is hiding over here. That means you explained everything perfectly.
Awesome, that's great. So I'll go over some of the resources that we're providing here. So the FLS referral form that I mentioned earlier, that's for the shelter-based attorneys. When you have survivors who are non-citizens, you can you can refer their cases to us through this form, and we'll screen them. And if we are able to, we can provide direct representation for their immigration case. Oops. The brochure that I mentioned on VAWA confidentiality and how to handle this in state cases, and in state court and your family court cases and things like that is right here. These are the actual statutes, and they're annotated and with when things came into because VAWA has been authorized and reauthorized several times, so it's gotten amended several times. And then the map of 287G agreements, if this is an interactive map, and you can just click on that link and you'll see all the jurisdictions in Florida, and actually all over the country. And you can click on the little pins that come up on the map, and it'll tell you what kind of 287G agreement it has, that jurisdiction, which police department has the agreement with ICE, and what it encompasses. And then one other resource that I wanted to share with you, the ILC Red Cards. They're similar to the ACLU cards on Know Your Rights. This is something that I encourage everyone to give their survivor clients, because it has their rights written. You can get it in a ton of different languages, and you can order them directly from ILRC or print them out, and that way your client has their rights. If they do encounter ICE at any point, then they're going to be able to actually enforce their rights. They can just hand them that card. You know, it says, I want to talk to a lawyer. I'm exercising my right to remain silent and things like that. So just like we hear on, from Miranda, and we know from, Law and Order and all those fun things, people in the immigration context also have the right to remain silent. They should exercise their right to remain silent. They should not tell ICE where they were born, how they got to the country, when they got to the country. ICE can figure all of that out on their own if they're intending to institute removal proceedings. So the survivor or the person, the respondent in removal proceedings, doesn't have a duty to give all that information. ICE has a burden to prove all of that. So we want people to know that they have the right to remain silent, and they have the right to an attorney at their own cost. So if you have someone that, like I said, if you need legal representation or at least a screening, you can always send those folks to us. And here's my contact information. If you have questions, if you have a survivor client and you're just not sure about something, please feel free to contact me. You can give the DV hotline number that's meant for the survivors directly. So I put that there also. They'll reach one of our 3 attorneys in the project, and we're an attorney operated hotline, and we'll be able to give them advice, but you can't call for them. We speak directly to the survivor through that hotline, but you can call or email me, and I'll be happy to help you and answer any questions you might have in your cases.
Thank you so much. We just had lots of compliments come in. No questions, just
Oh,
on
thank you.
great presentation. So thanks again for doing this, and thank you everyone for joining us. And I will see you in 2021. Happy holidays, everybody.
Happy holidays. Thank you, everyone.
Bye-bye.
Bye-bye.